Hello guys, my name is Tejas Sudhakar and we are back with another video. So in today's video, what are we going to discuss? We are going to discuss one of the most fundamental concept in your whole company law. Okay, I think by now, anyone who's watching this video, you are either already a CS executive student or are you considering to join CS executive or you have started preparing. Okay, so now that you are here, we all can agree on one fact that that company law is going to be one of the most important subject in your CS executive. In fact, not just for your CS executive, it's going to be one of the most important subject for your whole CS journey, because everything you're going to study, okay, whether you let it be your security laws, let it be your company law, let it be in your professional IBC corporate restructuring, everything starts from your company law. Okay, not just companies act. Remember the word that I'm using, I'm not just saying companies act 2013. Yes, companies act 2013 is the current common law in India, sorry, current company law in India, but then company law is a subject altogether. Okay, there are so many concepts which are not there in the bare act, but these are the concepts which made companies act 2013. Okay, so understand what is company law. Company law of course includes companies act 2013, but most importantly, what is more important, is your fundamental principles, which have helped us in making companies act 2013, which have helped us in making companies act 1956. And that's how important these functions are, these fundamental principles are. See, and today's concept, as you can already see it on the screen, it is the doctrines that we are discussing. All the doctrines from chapter 1. All the doctrines from chapter 1, one short video. With this one single video, you should be able to understand, most importantly, the fundamentals of the company law, all the doctrines that we need. And secondly, most importantly, you will be prepared for exam to tackle any question, literally any question that may come across in your examination or in your question paper. You will be 100% in a great position to answer it. Okay, so, and also speaking about weightage, this topic might not have so much weightage with respect to your examination, but with respect to your profession and your CS journey, both your examination journey and your professional journey as a CS, this video is going to be a gold mine. Trust me on this, just this one video. Okay, you'll be wasting so much time in watching so many other videos. Just for this one video, please watch till the end. Okay, I will be covering every single doctrine in chapter 1 of your company law subject, and also understanding why do we have these doctrines in the first place. Okay, not just studying it, but to understand the motivation behind it. So this is going to be one of the most important video. Don't think that the weightage kami or weightage is less, so I'll not be watching this video. Please don't do that. Trust me, they might not be asking too many questions from this, but if you understand this, every other concept you will be studying in company law comparatively becomes simpler. Comparatively becomes simpler. Okay, so let's get started. Okay, so doctrines of corporate personality. Okay, lifting of the corporate veil and alter ego. I've covered other doctrines also. Don't think that only these are the two doctrines I've covered. There are other doctrines, but the reason why I only mentioned these two doctrines in the heading is because these are the fundamental doctrines which will help us understand other doctrines better. So if we understand lifting of corporate veil and alter ego, they both are very much similar. We'll see how similar they are and what is the difference between it and what is the confusion that most of the students have. And also one more thing that I forgot to tell you, till now, if at all you have studied chapter 1, okay, if at all you have studied chapter 1, most of the students feel that they have understood doctrines. But in reality, they would not have understood doctrines in the truest form. To understand doctrines in the truest form, you need to understand why behind these doctrines. Why do we have these doctrines in the first place? Okay, so first thing, let's talk about features of the company. Let's talk about the features of the company. Okay. Okay, let's talk about the features of the company. One is your first, like anything that you can come across. Now I'll just think of some of the features. Okay, capacity to sue and be sued. Second, perpetual succession. Perpetual succession. Perpetual succession. Then hold the property in its own name. Hold the then then most important one, limited liability. Limited liability. Okay, then fifth, okay, then fifth is your common seal. Okay, these are some of the features. We don't have to write all the features to understand this. Okay, first let's understand, why do we need company form of business? You have multiple forms of business, right? You have multiple forms of business, but why are you only choosing company form of business? What is the need to choose only company form of business? Because of limited liability. Now the question comes, sir, this actually, one student asked me this question and it's a brilliant question. She asked me, sir, if limited liability is the only benefit of company, which is true, main benefit of a company is its limited liability, and that's why people incorporate companies. So her question was, if at all limited liability is the only reason why we are going for company form of business, why can I not give that same feature to partnership firm, to a sole proprietorship? Correct? Makes sense. Makes sense, right? At least if not, let's say partnership firm, maximum 50 partners you can have. Okay, up to 50 partners, you can do the business with limited liability. Yes, I agree, you have limited liability partnership, but forget about that you had limited liability partnership. I can give limited liability even to sole proprietorship. We will not, if at all I give sole proprietorship limited liability, I will not need one person company. Correct? We have one person company where only one single shareholder will be there in that form of company, and we will not have to give him, and we will not need one person company if I give limited liability to sole proprietorship. Correct? No. If at all I am giving the same feature to sole proprietorship, I will not need a one person company. Logical, right? The reason is simple. Now let's say Mr. A took loan from Kotak Mahindra Bank. Okay, let's say Mr. A took a loan of, let's say, 1 crore from Kotak Mahindra Bank Limited. Now is it mandatory? Is it mandatory for Mr. A to pay back this 1 crore plus interest? Yes, of course he has to pay back. Now, just because A is not repaying the loan, let's say A did not repay the loan, can Kotak Mahindra go and catch hold of Mr. B? And I'm assuming that Mr. B did not give any guarantee or surety in favor of A. Now, can Kotak Mahindra Bank go and ask to pay Mr. A, Mr. A's 1 crore loan? Can Kotak Mahindra Bank ask Mr. B to pay? Of course no. How can you ask? Now tell me one thing. I have taken a loan. Will you repay my loan? Or you have taken a loan. Will I repay your loan? No, right? Because it is that person's loan. It is not your loan. Okay. Similarly, this, even if the government wants to give limited liability to a sole proprietorship, it cannot give. It is impossible to give it to sole proprietorship, even if the government feels like, no, I'll give it to sole proprietorship, because sole proprietorship andre, I am doing the business, not the company is doing the business. But when I do the business in company form, it is as if company is doing the business. Company is doing the business. Now Reliance, okay, let's say Tata Motors. Now we are saying that Tata Motors is manufacturing the cars. Tata Motors is the one which is manufacturing all the automobiles that we see on the road. It is not the management which is manufacturing. You understood the difference? Because company has one feature called as separate legal entity. Separate legal entity. This one feature, because of this one feature, we have all these 5 features. Because it is a separate legal entity, you have capacity to sue and capacity to be sued. And one more important feature that comes from separate legal entity is its artificial person. In the eyes of law, a company is a separate, distinct entity. It is an artificial person. I will see another company as an artificial person. I'll see another company as an artificial person. It is different from its management. It is different from its shareholders. So company is a separate person and the directors are separate persons. It is only company acts, takes decision or takes actions through directors. Okay. So directors are merely agents of company. They're merely agents of the company. No, who is an agent? When one person acts on behalf of another person. No, isn't director acting on behalf of the company? Yes, 100% director is acting on behalf of the company. So there is a principal and agent relationship over here. Now you can directly connect this to your Contract Act 1872 in your GIJ. Okay, next. Okay, what was I telling? All these 5 features are coming from separate legal entity. See, when one person dies, does it mean the other person dies? No, of course not. Now, company is an artificial person. If the director dies or if the shareholders die, why should the company die? There is also a big case study. Okay, there is this very unique question that keeps coming up in company law, which you can always ask your friends also. If at all there are 10 members, then 10 directors in the company who are also the shareholders. And these are orphans. Literally, no one is there in the company and literally they don't have any family members or anyone. All these 10 shareholders go to a city to conduct their board meeting, and let's say for some unfortunate reason, all the 10 directors who are also the only shareholders in the company, they die. Now, do you think the company is dead or alive? Now all the shareholders are gone. All the directors are gone. Do you think the company is gone? No. Company is not dead. Company will continue forever. That is your perpetual succession. Why? Because company is a separate person. Shareholders are a separate person. Now hold property. If I can take loan, you can also take a loan. If you can hold property, I can own property. I can go and purchase a 30-40 site. I can go and purchase the 1 acre of land. I can go and purchase an intellectual property. I can go and purchase a share. All these are properties, no? Now, if I can do it, another person can do it. Now, another person can be both natural person as well as artificial person. As well as natural person as well as artificial person. So, company is an artificial person. So, company can also hold the property in its own name. This is how. If you understand separate legal entity, you will understand automatically all the features of a company. If you understand separate legal entity, you will understand all the features of company. Okay, this is why we cannot give limited liability to any other form of business. We can only and only give it to company form of business. Remember this. The whole reason or the root cause of why we have company is because of this reason, because company is considered as a different person in the eyes of law. One person cannot be liable for the debts of another person. One person's property cannot be another person's property. This simple concept. And that is your first topic for today. The foundation, separate legal entity. Okay, let's read it. Before understanding the exception, one must understand the rule. Concept, privilege and general rules, divided into 3 parts. Okay, the company is a distinct legal person. What is it? It is a distinct legal person, separate from its members. It is separate from its members, that is shareholders. This separation creates a corporate veil. Now, I incorporated the company. I am the first shareholder in the company. In that company, though I am the shareholder, I am different and the company is different. There is Or think of it like there is a curtain between me and the company. There is a curtain between me and the company. Are you guys understanding? There is, veil is nothing but your curtain. Okay, this is what separates the company from me. So when I incorporate a company, I gave birth to another artificial person. Who? The law is giving birth to another artificial person. The law is giving birth to another artificial person. Okay, that is where you have the concept of corporate veil that shields the individuals from company's liability. It shields the company's liability and obligations to whom? Individual is shielded because of corporate veil. Now, if tomorrow company takes a loan, it is not my loan. It is company's loans. Okay, it is company's loans and not my loan. Okay, general rule: the company can own property in its own name. It can take loans or it can incur debt in its own name. It can sue another person in its own name. Someone can sue the company. What is suing? Suing is filing a case against another person. So you can file a case against the company. Company can file a case against another person in its own name. Okay. The members are generally not liable for company's actions. One keyword that you need to pay attention: generally. Okay, generally, members are not liable for company's actions. Generally, members are not liable for company's actions. This is just one fundamental principle. Remember this. In today's video itself, we'll come back to this. Okay. So they are saying that in most of the cases, company's actions will not bind the shareholders. Okay. In other words, shareholders will not be liable for the company's actions generally. So now they are trying to tell that there might be a scenario where shareholders will be responsible for company's actions. Shareholders will be responsible for company's actions. Okay, shareholders will be responsible for the company's actions. Okay, I hope this is clear. Next, the second most important doctrine is doctrine of lifting of corporate veil or piercing of corporate veil. How will you read this? When it has to work, it doesn't work properly. Okay, lifting of corporate veil or piercing of corporate veil. Lifting of corporate veil or piercing of corporate veil. Okay. Now, what does it say? This is an exception to the rule of separate legal entity. Underline this exception. Why are we saying exception? Because these both are connected. Because what did we see before? Generally, companies' actions do not bind members. In other words, shareholders are not bound by the actions of the company. They said generally. So there is an exceptional circumstance where shareholders will be bound by company's actions when it is the act of it is a judicial act. So the law is looking behind the corporate facade. What do you mean by corporate facade? Is nothing but your corporate veil. It's nothing but your corporate veil. Okay. Corporate facade is nothing but your corporate veil. Now there is a curtain between me and my company. If I am doing any fraudulent activity, the law will look behind the curtain and say, see, company cannot act on its own. If company is doing fraudulent activity, that means you are doing fraudulent activity. See, remember what was the word that I used? I used the word artificial person. What do you mean by artificial person? It does not have any intention. It does not have any thought process. It does not have the thinking ability like you and me. Company is merely a artificial person. So if it wants to commit a fraud, it cannot have the intent to commit the fraud. If company is committing a fraud, the law will assume, see, company cannot do it. Why? Because it is an artificial person. Think of it like a brain dead person. Brain dead person, can he think and decide? No, he cannot think at all. He's a brain dead person. Think of company as brain dead person. If he is doing something, that means there is someone behind the company who is making company do that particular act, and that person, it can be your shareholders, it can be your directors, or it can be anyone who is using corporate veil to say that, sir, I did not commit fraud. Who committed fraud? Who committed fraud? The company committed fraud. And this is how most of the people defend themselves for the actions of the fraudulent actions of the company. But the law says, no boss, you cannot misuse this benefit that I have given. Now, corporate veil is the benefit that I have given you. You cannot use this benefit. You cannot use this benefit to take advantage of the concept of company or the limited liability that I have given you. Remember this. This is lifting of corporate veil. So first what did we understand? Separate legal entity. That there is a corporate veil between the company and the shareholders, and whenever needed, that means whenever the company commits the fraud, the law will remove the corporate veil and look into the eyes of the directors who are acting through the company, acting for the company, and make sure that the directors are personally liable for the actions of company. Now the benefit of limited liability goes away, because you got limited liability only because of corporate veil, and the moment the law removes it, the concept of limited liability just goes away. And now directors will be treated like sole proprietors, and they will be personally liable. This is the concept of doctrine of lifting of corporate veil. Okay, the court lifts the veil of incorporation to hold the individuals behind it responsible. We are the individuals. Remember, individuals, whenever the law says individual, any provision, literally any provision, whether security laws or company, whenever they say individuals, they mean to say natural persons. They mean to say natural persons. Okay, they mean to say natural person, to prevent the abuse of corporate form for illegal, fraudulent, or unjust purposes. Okay, when is it lifted? In two broad categories. Okay, when do courts lift the veil? In two broad categories: statutory recognition, that is false information, fraudulent removal, and fraudulent conduct. Okay, do not worry, you will get these notes in the description down below. You can just click the link, okay, and you can download it, so you don't have to worry. Okay, that is the most common question that I get, sir, where can I find the notes? It will be in the description. Okay, so what is the false information? Punishment for furnishing false information during incorporation, liability for fraudulent application to remove a name from the registrar of companies. Okay, then liability of conducting business with the intent of defrauding the creditors during the winding up. You are defrauding the creditors. You have taken the loan with the intention that tomorrow I'll close the company and say that I don't have the company anymore, and the company will not be in a position to repay the loan. Okay. Then the second case is judicial interpretation. Wherever there is fraud or improper conduct, the court will come and say that I will lift the corporate veil, and to protect the public policy. These are the two cases that you need to remember: Jones versus Lipman and Daimler Company Limited versus Continental Tire and Rubber Company. Okay, go back after this video, read these case laws. Now you will understand it just like this. Okay, remember this. Okay, then prevention of tax evasion. These are the case laws. Okay, so go back, look at these case laws. I have even given the simplified notes in with this document. So make sure after this video, download this PDF, watch this, and then watch this and read the concepts once again. I am 100% sure after this video, you will have zero doubts. If at all you have doubts, please feel free to reach out in the comment section below. I will surely respond to those comments. Okay, make sure you are dropping your comments down in the dropping your doubts in the comment section down below. Okay, clear? And also there is one more clip that I want to show you. There's one more clip that I want to show you. Okay, I think, wait just a minute. is it? Where is it? Where is it? Is it this one? Yeah. Watch this video. This is the most.
First of all, let me clarify here. When you keep saying you borrowed, I never borrowed one naya paisa. Vijay Mallya has never borrowed a single rupee from anybody ever. It was Kingfisher Airlines, the running company that borrowed. I was a guarantor. First of all, let me.
Brilliant narrative, right? All he's saying is, Arey, I did not borrow, Kingfisher Airlines borrowed. Arey, he committed fraud. He diverted funds from Kingfisher Airline to other offshore entities. That was fraud. Okay. This is anyone who is showing sympathy to Vijay Mallya after this podcast did not attend company law classes. Remember this. Okay. Did not attend company law classes. They do not understand how company law works. They do not understand the concept of corporate wealth, but you do now. Okay. So what he is trying to say is he's trying to play the sympathy card. Okay. What he's simply saying that, let me be clear, I did not take the loan. Kingfisher Airlines took the loan. Kingfisher Airlines did not repay the money back to the bank. I am not responsible. This is the most dumb argument that anyone can make to say that you are not liable. And by the way, he was a personal guarantor for this. Whatever loan Kingfisher Airlines has taken, he gave personal guarantee saying that if Kingfisher Airlines does not repay, I will repay. So, this is how people use corporate wealth, just to make sure that we do not have these kind of people who say that they take how much ever loan they want and tomorrow they will say I did not take the loan. To prevent this from happening, we have the doctrine of lifting of corporate wealth. Okay, now coming to doctrine of alter ego. What does alter ego mean? The other I. Okay, it implies a second self, an identical copy. It treats the company and its controllers. Who are its controllers? Your controllers are your directors and shareholders as one and the same. Okay. When do you use it? When do you say that whatever company does, it's the directors doing it? Ideally, that's what is happening. No, if a company is taking a decision, it's the directors who are taking the decision, right? So now you have to equate them. See, I will only give you the benefit until and unless you use it for a right purpose. If you're using for wrongful purpose, I will not give you this benefit. That is what alter ego says. Alter ego establishes a theory. It establishes a theory that whatever company does, directors are doing it. If the directors are doing anything that's right, then I will give you the benefit. If the directors are making company do any fraudulent activity, then I lift the corporate wealth. Okay, function. It is a theory or rationale used to justify lifting of corporate wealth. To apply lifting of corporate wealth, you need to apply alter ego. Without application of alter ego, you cannot apply lifting of corporate wealth. Why do you say so, sir? Because I have to first say that directors are the one who is acting on behalf of the company. So I am trying to equate company's actions with directors' actions. I am trying to equate company's actions with directors' actions. Okay, so basically I am saying that whatever company is doing, directors are doing. Only when I establish this, only then doctrine of corporate wealth can be used. You cannot use corporate wealth without establishing alter ego. So if you are a lawyer who is saying that this company is using company to do fraudulent activities, your first step now you are asking the court to lift the corporate wealth. You should not directly ask the court to lift the corporate wealth. You should ask the court to accept that there is alter ego, and then the court will automatically lift the corporate wealth. So first step is establish alter ego, then automatically court will lift corporate wealth. Okay. So there are some differences between doctrine of lifting of corporate wealth and doctrine of alter ego. Now, what is lifting of corporate wealth? What is lifting of corporate veil. It is judicial action. It is a judicial action of disregarding the separate entity status. It disregards the separate entity status. But to establish lifting of corporate veil, you need to establish alter ego. I'm repeating this again and again. It is a theory. It is the ground on which you can request the court to lift the corporate veil. It is a specific rationale. The other I theory used to justify the act. Now, if the company has committed fraudulent activity, doctrine of alter ego says that directors have committed it. Once I establish that directors are the one who have committed this fraudulent activity, then automatically I can lift the corporate veil. It covers many grounds. Okay, fraud, enemy character, tax evasion, all these case laws we have seen. Okay, then it focuses on the consequence, removing the shield or removing the veil to reach the reality. Who is the reality? Directors or the shareholders who are acting on behalf of the company. Okay, and alter ego focuses on the relationship, establishes that person and company are essentially the same person whenever a fraudulent activity is happening. Whenever a fraudulent activity is happening, doctrine of alter ego says director and the company are the same. So now I will lift the corporate veil. Automatically the corporate veil gets lifted. Okay, the court lifted the corporate veil because company was a sham. What do you mean by sham? Something that it's a scam. Okay, the court applied the alter ego doctrine because the director was directing mind of the company. Okay, so they have given the summary. You can and make sure to download this document and read it. Okay, now coming to doctrine of constructive notice and doctrine of indoor management. Okay, and exceptions to doctrine of indoor management. Okay, that's it. These are the two doctrines that are left for our today's video. Okay. Now, what is doctrine of constructive notice? See, who is giving the benefit of a company? Government is giving. Now, if let's say you are the government, like let's say anyone who's watching this video is the government, you are giving me the benefit of forming a company. You have given me the right, the entitlement to form a company. Now, as a government, you have a responsibility. You have a responsibility that Tejas does not misuse this. You have a responsibility that Tejas does not misuse this benefit that I am giving him. That benefit is starting a company. Now, to make sure that no one in the public is cheated because of me, you say, give me some documents. You say, give me some documents. What are the documents you are asking? My memorandum of association, my articles of association. Broadly, these are the two things that you are asking me at the time of incorporation of the company. Why? Through memorandum of association, you will know what is my company's name. You will know where is my company situated. You will know what will be the objective of my company. You will know who are the shareholders of my company. You will know what is the kind of liability my company has. You will get to know everything about my company. If tomorrow something goes wrong, you know where to find me. So this is the whole purpose of why you are asking me this information. Now you are asking, okay sir, you are talking about memorandum of association. Sir, then why do we need articles of association? Sir, the government need articles of association for mainly one reason. Articles of association, what does articles of association tells? Articles of association tell that how should a company take a decision? What is the procedure that the company should follow on a day-to-day basis? It is basically company's internal rule book. It is internal rule book. Now, even this should be public information. No? Tomorrow, if company is taking a decision with respect to something and public is involved, public should know if I am following all the procedures that I said I will follow in the articles of association. This is the whole purpose of giving these two documents to the government, and government makes it public. Once this document is public, that means that all the information is now public information. Anyone today, okay, if you pay reasonable amount of fees, you can get every company's memorandum and articles. With this, you will know whether company is authorized to take decision, whether the company is authorized to take a particular decision. Okay, that is doctrine of constructive notice. Now, the fact that memorandum and articles are public information, it is as if I, as a company, have given notice to the public. Have given notice to the public. It is deemed to be a notice to the public. See, I am a company and I have incorporated, this is my articles and this is my memorandum, here it is. It is constructive notice. It is construed to be a notice. Now tomorrow, okay, let's say, I am into textile manufacturing. I enter into contract with one of the person, let's say Rakesh, okay, with respect to telecom sector. My actual business as per my memorandum of association is textile manufacturing, but I entered into contract with him for telecom industry. Now, don't you think there is a conflict here? My actual objects of the memorandum says that I am into textile manufacturing, but I am entering into deal with telecom industry. There is a conflict between these two. Now, will this agreement be void? 100% this agreement will be void. And tomorrow, let's say I had promised Rakesh to pay 1 crore for this deal and I do not pay him 1 crore. Tomorrow he cannot enforce this contract against me. That means no one can force me to pay this 1 crore because of doctrine of constructive notice. Rakesh should have checked my memorandum of association. Why? Because it's a public information. It was his responsibility to check my memorandum of association before entering into a deal with me, before entering into an agreement with me, before entering into a contract with me. It was his responsibility to check whether my company is authorized to do this act or not. Whether my company is authorized to do this act or not. Clear? This is doctrine of constructive notice, whereby it is protecting the company. It is protecting the company against outsiders. Rakesh was an outsider and it is protecting me. Who am I? I am the company. Why? Because it was a public information. It was construed to be given a notice to him as well. Even he is a public. No. Now the fact that I filed my memorandum and articles with ROC, with the government, is enough reason for me to say that I have given notice to him. So doctrine of constructive notice can be used this way. Okay, it is a public document. The memorandum and articles, once registered, become public documents available for inspection by anyone. Okay, the presumption, now the law will presume that he knew memorandum of association of my company and still he entered into agreement with me, so it is his fault. Every person dealing with the company is deemed to have the notice of the contents of memorandum of association or articles of association. Okay, what is the key principle? Ignorance of law is no excuse. Ignorance of law is no excuse. Okay, you have a legal maxim in JIGL law as well. With respect to ignorance of law is not an excuse. Okay, now there are some case laws. I am sure that now if you read the case laws, you will have 100% clarity with respect to this. Now, doctrine of indoor management. Now, what was doctrine of constructive notice saying? It is protecting the company against the outsiders. Now, doctrine of indoor management says, I will protect the outsiders from the company. Under what cases? Now, there are certain things which is not a public information. For example, let's whatever example we took, what am I? I am into textile manufacturing. What is the contract that I entered into? It was with respect to telecom industry. Now in this case, there was a conflict. Fine, sir. Fine. Now let's say I entered into contract with respect to telecom manufacturing. Now it is not ultra-virus. Now it is not ultra-virus, nor it is doctrine of constructive notice can be applied because we are entering into textile manufacturing. It is not a void contract. Okay, it is not a void contract. Okay. Now think about it. If it is not a void contract, but let's say my articles of association, forget about articles of association. I was supposed to take this decision of telecom manufacturing by taking shareholders approval. And I had not taken shareholders approval and I did not tell anyone. And Rakesh assumed that I would have taken shareholders approval because it was not public information. Now he gets the right, he gets the ability to presume that I have followed all the rules. What was the rule? That I have to take shareholders approval. Now he can presume that I have followed that rule, but I have not followed. And there is no way Rakesh can get to know that this rule existed, and there is no way that Rakesh can inquire whether I complied with this rule or not. Now tell me, is it Mr. Rakesh's fault? Of course it is not his fault, it is my fault. Now the law says I will protect Rakesh because it is not his fault. Okay, in doctrine of constructive notice, it was his fault. In doctrine of indoor management, it was my fault. Because what happens inside the company and which is not a public information, an outsider cannot know about it. Therefore, in this case, the law protects outsiders from the company, whereas doctrine of constructive notice, it protects the company from the outsiders. Okay, I hope this is clear. If you understand this, today's video has helped you 100%. Okay, if it has helped you, you know what to do. Like, share and comment. Okay. The doctrine protects the outsiders against the company. It is the counterbalance to doctrine of constructive notice. It is opposite of constructive notice. No, doctrine of constructive notice is, I'm repeating again and again, I know, but this has to get absorbed in your system. Doctrine of constructive notice protects the company from the outsiders. Doctrine of indoor management protects the outsiders from the company. The core concept, an outsider dealing with the company in good faith is entitled to assume that all internal rules, procedures and formalities required by AOA have been complied with. Okay. The rule explained, while an outsider must check memorandum and articles, they are not expected to investigate whether internal procedures have been followed. How will he know whether I have taken shareholders' approval or not? And to establish this, you have a case law called as Royal British Bank versus Turquand, and doctrine of indoor management is also called as Turquand rule. It is also called as Turquand rule. Okay, it's the same example. Outsiders are bound to know external position of the company, but the outsiders are not bound to know the indoor management. Okay, but there are some exceptions to doctrine of indoor management, that is knowledge of irregularity. You knew that he did not take shareholders' approval. Somehow you got to know. It was not a public information, but let's assume you got to know. And still you entered into agreement to make sure that tomorrow you can use doctrine of indoor management. Sir, it was not public information, so we have to apply doctrine of indoor management. But then the court will ask him the first question: did you know if he complied with that rule or not? If he says yes, over. If we can prove that Rakesh knew that I did not take shareholders' approval, yet entered into contract with me, it is his fault or no? Here the only point you need to remember between doctrine of constructive notice and indoor management: did the outsider know about it or not? If the outsider knew about it, he is at fault. If outsider did not know about it, it is my fault. Okay? In doctrine of indoor management, if he did not know it, it's my fault. If he knew it, it is his fault. Okay? Then, no knowledge of memorandum and articles. He said that, sir, I forgot to see memorandum and articles. It is your fault. Doctrine of constructive notice. This is nothing but your doctrine of constructive notice. Forgery. The rule does not extend to transactions involving forgery. If there is anything involved in forgery, then you cannot use this. And if at all there is negligence. You had a suspicion that I did not take shareholders' approval. You should have inquired whether I took shareholders' approval or not. See, if you did basic due diligence, if you verified in the most basic manner, the situation was such that you could get to know that whether I have taken shareholders' approval or not. It is your fault that you did not do it. It is your fault. Court is telling Rakesh, Rakesh, if you just did some basic due diligence or basic verification, you would have gotten to know he took shareholders' approval or not. Now the fact that you did not do the basic verification, you are at fault. That's it. You are at fault. Okay. Then the difference between constructive notice and indoor management, the company against the outsiders. It protects the company against the outsiders, and doctrine of indoor management protects the outsiders against the company. Who invokes constructive notice? The company. Who invokes inside indoor management? The outsider. Presumption: outsider is presumed to have read and understood memorandum and articles. Remember, read and understood. I will assume that you have read it. Tomorrow you should not say, sir, I read it, but I did not understand it. That is not a good enough defense. Okay, outsider can presume internal formalities have been complied with. Scope of duty, external power. Okay, outsider is not required to verify internal procedures. Okay, but there are some exceptions to this rule. Okay, then general relationship, it shields for the company. Then it is a counter shield or balance to constructive notice, whatever we have discussed. Okay, if at all this video was helpful, make sure to share it with your friends. Okay, I am sure if you understand this one concept right, I am sure automatically you will start understanding other concepts of company law. Okay, you will start understanding the other concepts of company law. Okay, in a much better manner. Okay, so please make sure to like and share this video as much as you can. Okay, and please download these notes so that it will help your studies tomorrow. Okay, so this, and also most important part of chapter 1 is only these doctrines. Okay, I hope chapter 1's almost the whole revision is done with this particular video. Okay, so I'll see you guys in the next video. Bye guys, take care.